Brianna Rucker. I am Diversity and Inclusion Committee Chair of the BHBA's Barrister Section, and I'm super excited to introduce our speaker today. His name is David Coher. David is a mediator and arbitrator at Coher ADR with extensive experience in legal practice, corporate counsel, and legislative service. He has held key roles at Southern California Edison, Irvin, Cohen, and Jessup, and as legislative counsel to a U.S. congressman. David also serves as an ADR panelist for the U.S. District Court, Central District of California, and has held numerous civic leadership positions, including chairing the Pasadena Board of Zoning Appeals. And now, without further ado, let's get started.
All right, great. Thank you, Brianna, for the introduction. Appreciate that. If we could go ahead and put the slides up, we can start with the presentation. All right. And let's go ahead and get started then. So as you all know, we're here to discuss real estate disputes and potential issues. First, a little bit about myself. So you heard some of my background earlier. Some relevant experience that I'll add to that is that I also am a past chair of the Planning Commission here in the city of Pasadena, which is where I'm actually sitting at the moment. And from that experience in Pasadena, it's been helpful for informing some of the background that we're going to be talking about today. If we could jump to the next slide, please, that'd be great. All right, so let's talk about why we are here. So California real estate disputes can often involve unanticipated legal complexities. Issues such as historical easements, municipal zoning quirks, certainly familial emotional overlay, and disclosure pitfalls. So this is something, it's an area where even the seasoned litigator can inadvertently make a misstep through the patchwork of statutes and local ordinances that are unique to the area of real estate practice. I want to be clear, this isn't meant to be a primer in terms of an understanding of the whole of real estate law in California, but rather to highlight some of the areas that I have seen issues arise. Also to provide perhaps some ideas for issues you may want to watch for in your cases. And really it's just a focus on those critical pitfalls that can end up diverting a case, unfortunately. With that, let's go ahead and head to the next slide, please. And the first area we're going to talk about is zoning, CEQA, and political momentum. And for that, we're going to talk about the case of Save Tara versus the City of West Hollywood. If we could go to the next slide, please. And we'll see some pictures here of Tara. Now, Tara was a pretty unique property. This certainly was not a black acre or white acre type of nondescript property as you often hear of in real estate cases from law school. The story begins with a colonial revival mansion, as you can see in the pictures, located on North Laurel Avenue in West Hollywood. Is originally built in 1914 and nicknamed Tara after the plantation in Gone with the Wind. It wasn't actually featured in the movie, mind you, it just was named after. In any case, is on beautifully landscaped grounds, is designated as a local cultural resource in 1994. In 1997, the then 98-year-old owner, Elsie Weissman, donated the property to the city with a life tenancy provision for herself. She passed away in 2000, and the property then became the city's in fee. So in 2003 is when our story really kicks off. And that's when the city began to take action to try and transform Tara into 35 units of affordable senior housing. To enable the financing of this construction project, that there's going to be a major remodel, it entered into an option and development agreement with a local nonprofit that offered to convey the property at a low cost and to contribute nearly $2.5 million in land value and loan assistance. This was all done before CEQA review, however. The city issued public statements celebrating a federal grant and relocation planning assistance. Staff of the city began engaging tenants about eviction timelines. Obviously, had to move out some of the folks who were in there in the units that already existed in Tara. And it was clear that the project had momentum, even though environmental review had not been initiated at all. There were press conferences and press releases and all of the like, as you can imagine. Well, neighbors who didn't want this project formed a group called Save Tara. It was a grassroots group opposing the project. They sued, seeking to void the agreements from the city and force CEQA compliance before the city could make any binding commitments. Now, at the time, the case law out there seemed to indicate that CEQA would only apply for the actual land use approval, which is why the city had moved forward in this manner. They thought they didn't have to engage in the CEQA process until there was an actual permit application or otherwise, zoning change, something of that nature, some land use provision that was before them. But the trial court ruled against them, reasoning that the agreement explicitly that conditioned conveyance and funding on the CEQA compliance. Save Tara appealed, and this when it went to the Court of Appeal and then the California Supreme Court, who disagreed. The California Supreme Court adopted an intermediate rule. So even a conditional agreement, such as what the city signed, that had a provision in it that technically said, no, this is valid until the CEQA approval, and we go through the full CEQA process and then the land use approvals, even that amounted to a de facto approval if, in context, the lead agency's actions, in this case, the city of West Hollywood was the lead agency for CEQA purposes, these, such as public statements, the financial commitments, the activities for tenant relocation, option agreements, clearly demonstrated a practical certainty about the project. And in such cases, the California Supreme Court ruled an environmental impact report must precede the approval, no matter how caveated the contract language might be. Today, Tara is still owned by the city of West Hollywood, and it is home to some affordable housing units as a small artist community. However, the project that was envisioned in 2003 never materialized, and largely because of this Supreme Court case, ended up causing too much delay, and then eventually the project died. If we could go to the next slide here, we can talk a little bit about what does it all mean here. I think our key legal lessons to take away are that project momentum at a lead agency can trigger CEQA requirements even with conditional terms. Now, let me talk about what a lead agency is. For those of you who may not be familiar, when you have a project, given the patchwork of local governments in California, especially in an urban area, you'll often have several different government agencies involved. That can mean both local and state jurisdictions. It could be special governments, so on and so forth. A lead agency is the one that is chosen by that ends up taking the lead on the project, and they have control over it. And the reason for this setup is to avoid requiring multiple environmental impact reports, multiple CEQA approvals, etc., etc. All right. The court here prioritized the actions and the intent rather than the legalese of the agreement, right? Putting the substance over form. And the public narrative that was presented mattered more than the contract clauses. Remember, there are lots of statements and pronouncements and press, um, various publicity around what was going to be done and how great it was. And the contract clauses were buried deep in the agreements as seen as a hook for technicalities. And the Supreme Court, the California Supreme Court in this case, saw through all of that and said, no, the city is taking an action, a public agency is taking an action. They have to treat it as a CEQA matter from the start of taking that action. And I think what we can learn here is that it really demonstrates how regulatory and political momentum can undermine those legal defenses when not anticipated early. In this particular case, the city of West Hollywood thought their legal defense was going to be that particular contract clause. And for mediation purposes, case shows that early recognition of zoning and project dynamics, including the public statements, the municipal behavior, kind of what the community's involvement was here for the land use, uh, show is crucial to a realistic risk assessment. If we could go to the next slide. I apologize. I'm just going to try and fix my light here, if I may. All right. Thank you. Let's talk about some of uh, I believe we talked about the key legal lessons. Now let's talk about the strategic mediation lessons here. So again, look for zoning dynamics early, as I just mentioned. The municipal politics are important to the situation, depending on the size and the scope of the project, that it could be important. It also could be something that while the municipal politics do not initially play into consideration in your analysis of your client's project, depending on what else is going on in that jurisdiction, there could be other issues where it comes into scope. There could be other developments where it could ensnare your client's project. So you want to work with someone who has that localized that local and specialized knowledge to be able to see those issues ahead of time. And on the flip side, the potential for using CEQA risk for managing a project that your clients may oppose. Conditional clauses are not going to provide you with immunity. So that's not going to be a solution to the mediation in terms of the settlement that's reached, because those are going to be found to be invalid. So it's going to provide you with little leverage. And then consider the substance of what's going on for the legal and public procedural risk. So discuss that zoning strategy early, exploring who else is on the horizon that could step into the situation and create a risk. One thing that mediator can do to help is to reframe that zoning conflict as risk management in the project. Especially because, let's be honest, the CEQA timing can be very ambiguous, right? It can be a lengthy process, and time can be a problem, if not kill many deals. Okay. With that, I think we've discussed that thoroughly. Let's go ahead and move to the next item here. We're going to talk about title and issues with the chain of title. And for this one, I want to talk about the City of Manhattan Beach. It's a case called City of Manhattan Beach versus Superior Court, but it actually involves a particular jogging path in the city. And if we could go to the next slide, please. You can see a picture of that there. So this jogging path's over a forgotten railroad. All right. So let's talk about the early 1980s in Manhattan Beach, a coastal community built atop sand dunes and rail beds. I'm sure most who are listening here are familiar, have been, but buried beneath what had become a public jogging path and a greenway was a legal enigma written in a 100-foot wide easement grant. Well, I guess that was actually the debate. Was it an easement grant or was it title and fee? And we'll get into that. The original grant came from 1888 by the Redondo Land Company and was to the Redondo Beach Railway Company, which eventually, by the time of our litigation story, would become part of the Santa Fe Railroad. It was a grant for $1, and the deed, as it was entitled, described the grant in a limited fashion as a right of way for the construction, maintenance, and operation of a steam railroad. So that's language that sounds like an easement, right? And an easement for a limited purpose, for a very narrow, limited purpose, the operation, the construction, maintenance, and operation of this steam railroad. Yet the document also used traditional remise, release, and quitclaim language akin to an offer of a full interest, such as if you were to sell land in full, a complete fee title. Well, many years later, obviously, steam railroads are not practical to be operating through Manhattan Beach today, and in the 1980s, the Santa Fe Railroad sold the land to the city of Manhattan Beach for park use. And obviously, this transaction was conducted by both the Santa Fe Railroad and the city of Manhattan Beach with the assumption that it had full legal title. Heirs of the Redondo Land Company. Now remember, the Redondo Land Company was the owner of the property that then made the grant to the Redondo Railway, the Redondo Beach Railway Company. The Redondo Land Company heirs surfaced and asserted that the railroad, for these purposes, Santa Fe Railroad, only held an easement, not fee title, and that therefore the Santa Fe could not sell it to the city of Manhattan Beach, and that they demanded compensation through claims for ejectment based on years of non-rail use, or in the alternative, inverse condemnation. Well, as you can imagine, the case made it to the California Supreme Court, which found the deed ambiguous. Okay, no surprise there. So it looked beyond the text. They considered how the Redondo Land Company had behaved afterwards, how the land was treated over the decades, and how subsequent transfers had implied full ownership without objection from the Redondo Land Company or heirs. So the California Supreme Court concluded that Santa Fe had received a fee simple interest, or more precisely, the Redondo Beach Railroad Company had received a fee simple interest, which then became the property eventually of the Santa Fe Railroad. And because of this, there was no compensation owed to the heirs. So in mediations, often disputes over title will hinge on similar ambiguities, and litigation can become this kind of generational tug of war. So the problem is that confidence is eroded when the parties realize that their assumed legal foundation, here ownership by the Santa Fe Railroad, is shakier than believed, and it's less a question of framing it as who's wrong. But for mediation purposes and reaching a settlement, it's really about questioning what is this really worth and what are the risks of continuation. In this particular case, now obviously I wasn't a part of the mediation of the case between the heirs to the Redondo Beach Land Company and the city of Manhattan Beach. But given the complete loss that occurred in this circumstance, it would be interesting to know what was offered by the city of Manhattan Beach and what the balance would have been for those heirs between what they eventually got, which was a large legal bill, and what they could have gotten from the city of Manhattan Beach earlier on in the process. If we could go to the next slide, please, we can talk about some of the key legal lessons here. So this was a deed dating all the way back to 1888. Here, the prior use of the land at the time seemed relevant to the purchase. For some reason, there was a desire to put language in about the construction, maintenance, and operation of a steam railroad into that grant deed, rather than simply having it be fee simple transfer. I suspect at the time, under knowing the history of the region, that was because the Redondo Beach Land Company wanted to ensure a railroad was being built on that land and not just more houses by the beach, because there was a transportation issue. There was a reason they were selling this piece of land for just $1. But that ended up causing unintended consequences down the road. So I think the lesson here is not just reviewing the title report, okay? Because this would not necessarily have been caught by a title report. It is reviewing the history of the land, the use of the land, and to see if there might be some question in that document, okay? In any of those documents that are in that chain of title that would be relevant to what you're trying to do with the land. In this particular case, for example, even if it hadn't been the city of Manhattan Beach buying this land for the construction of this public greenway, let's say that there had been a different bidder, that Santa Fe Railroad had sold it to a home developer, more houses were built in the space, which certainly would have been an economically beneficial use of the land in by the early 1980s. Nonetheless, you would have had the same issue, and there is a question of how the court would have considered that balancing of the equities at that time, with a different purpose for the land. Here, the courts did look beyond the text to the behavior, and for a similar situation, your client may need to assemble evidence of land use, of the transfers, and of long-term control. What was done with the land during the period in question? Here is a period of nearly 100 years. Historians may be a good option for this if funds allow. There can be local historians. Sometimes local historians will be employed for getting a particular property to be declared for historical status, such as a Mello-Roos tax exemption. Alternatively, there may be other historians who may be relevant to the discussion. That's something to look into and consider beyond just obtaining a title report and title insurance. And also understanding that the transactional horizons may not allow for a resolution in time for what the project is. Here, the project was used as a greenway by the community. There was not a time limit on it in the way that my hypothetical developer who may have purchased that land from the Santa Fe to build homes on, they may not have been able to make that project pencil out given the time that would be required to take a deed from the 1880s all the way to the California Supreme Court. Okay, so that's something to think about too in terms of these issues that may crop up and that you may find as you're working on putting the case together. If I could have the next slide, please. Let's talk about some of the strategies for mediation here. So as we've talked about, title reports are not the whole story. I doubt that something like this would have been discovered and highlighted on the title report for a project, and certainly for a similar project, it's going to be a development of some type. These ambiguous deeds can mean uncertainty and leverage. So having a strong story to tell us that as the dispute spanned over a century, involving descendants who never saw the land, and it turned on subtle wording differences beyond what, quite honestly, even most lawyers would understand to have been a problem. I think that's something where you'd have to be specialized and knowledgeable about real estate matters to understand the significance of the language that's in that deed that I quoted for you earlier. And again, not just have reviewed the preliminary report, but also have actually reviewed the document, the underlying deed document itself, which also can mean being able to read the underlying deed document. As those who have delved into these matters know, those documents can sometimes have legibility issues. Uh, that being said, the city had long acted like the true owner, maintaining the paths, installing various improvements, etc. And so that also can that ended up providing help here in the California Supreme Court's ultimate analysis and their decision. But in mediation, one other lesson here, I should say, is shifting the conversation from the all or nothing discussion of the legal minutia to really getting into what's another year of litigation really worth, right? Now, one benefit here that the city had going for it is that the longer it took for the litigation to continue, the longer these neighbors, the members of the community, had the beneficial use of the greenway, right? So time was not an issue of leverage for them. Okay? You want to take a look at that when you're examining something like this for clients. All right? Let's go ahead. I'll just take a moment to note that if before I jump into the next section here, well, that's fine. You can move forward to the next slide regarding partition actions. But I just want to note, if you have questions that come up, please enter them in the Q&A box. We have that feature here, and I will be going through those later. I don't believe folks have access to the chat, and I don't have access to be replying in the chat. But if you do have questions, feel free to use the Q&A so that I can address them later. Okay, with that, then let's go to the next slide so I can start talking about partition actions. And I've got two examples for you here. There we go. All right. So now, in California, California law grants real property co-owners an absolute right to partition. It's Code of Civil Procedure 872.210. Uh, but every co-owner has a statutory right unless it is waived in writing. However, this can be difficult in practice. All right. So let me share with you a story of family dynamics, legal rights, and the emotional attachments all coming together and colliding in a partition case. This is a story of two brothers, Adam and James, who had recently inherited a modest but very well located duplex in Los Angeles from their mother who had passed away. Adam was the younger of the two brothers. He lived in the upstairs unit for over a decade after moving back when their mother's health began to decline. He stayed on in the home after her passing. He was maintaining the home, paying the utilities, handling minor repairs. Really, to Adam, it was more than a property. It was home. The garden still had the mother's rose bushes. I remember him discussing. I mean, the dining room was filled with Thanksgiving memories, right? I mean, all of the trappings. So his understanding was that there was an unwritten agreement that he had earned the right to stay in the property. Okay, but James was the older brother. He lived out of state. He hadn't visited much the last few years. He had run into trouble with a failed small business, unfortunately, and a divorce. He saw the duplex as a lifeline. He needed his share of that equity. He felt justified in pursuing it. He thought there's nothing formal that specified what the rights were going to be. In terms of the transfer, it was left to both of them. It passed on to both in equal shares. Okay, so unable to come to terms with Adam, James sought out counsel, filed a partition action and they were asking the court to force a sale because of this. Adam felt blindsided. Uh, he really wasn't prepared to deal with the business matter at hand. When he came to mediation, he was angry, defensive. He was holding on to the emotional and personal issues involving the home. And he really was holding firm that his brother was violating their mother's wishes. Claimed that she had always said he could keep the house. Of course, there was nothing in writing as to this. Um, at one point, he said, it's not just a building to be bought and sold. And, now, unfortunately, as lawyers, we know, well, that is kind of what it is. Obviously, I didn't say it to him in that way, but that's the reality of the matter, right? And there's a lot of emotion around that, and he felt it was all that he had left of his mother. James, on the other hand, had a very clear-eyed view. He came prepared. He understood. He came with counsel. They understood what their rights were. But this is a case where obviously there were clear legal rights involved. It was going to be messy to be able to, it was going to be time consuming to finish the process, and it was going to be messy to then complete the sale after having won in court. So, in this case, the mediation wasn't just about the legal outcomes, it was about the resolution. And what stood in the way here was not the Code of Civil Procedure statutes, it was the pride and the deep sense of personal injustice, of Adam having felt betrayed. James, meanwhile, I've been talking about him being hard-nosed in this, but he also felt that he had been ignored in this, that his needs, as he had fallen on some hard times recently, as I mentioned, were being ignored by Adam, and that Adam was living in this largest duplex where he, had all this empty space. He could easily take his half of the money, James felt, and Adam could live somewhere else. It wasn't like James was trying to put Adam out on the streets. So he thought Adam was overreacting to the situation and ignoring James's needs, especially his financial situation. There are a lot of practical and human concerns here. Now, eventually, we were able to work out an arrangement. Part of this was getting Adam to get an understanding that the court wasn't going to be able to enforce his sentimental claim. And James also recognized that forcing a sale was going to have two negative impacts. First, from the business side, lower market value, right? There's hair on the deal, so it's going to be troublesome. But beyond that, it also was going to have long-term impacts and really foreclose the relationship between the option of, excuse me, foreclose the option of repairing this relationship between the brothers. So with that, we were able to work out a situation where uh, independent values were going to be obtained as to what the proper valuation is, for Adam to get financing to be able to pay James a lump sum so that James could be able to take care of his financial concerns, while Adam was then able to operate the property, rent out the other unit, and make the payments on the loan that he had obtained. It wasn't a complicated real estate transaction here. It was, I mean, there were some unique bits to it, but really at the end of the day, it was about getting people in the right place to be able to understand this and to be able to consider these with a clear mind. If we could go to the next slide. We'll talk about the legal rights involved here. First off, as an absolute right, as I discussed, the Code of Civil Procedure. And by the way, there's a citation slide at the end that's going to be in the written materials of this and all the other cases. But there also were problems nonetheless. James had to pursue the lawsuit. He had to spend some time and money on it, and risk the destruction of an otherwise positive familial relationship. Uh, so those are costs that the Code of Civil Procedure cannot reimburse you for. It can't protect you from. All right. Let's talk more about the strategic mediation lessons to learn from this example. Uh, so this is really the legal right to partition meeting the emotional resistance, and that legal clarity does not necessarily equal win. Right? The partition rights may be black and white, but those sibling dynamics are anything but. Reframing this helped bridge the financial needs on James's side regarding and the emotional value that Adam was finding in it, and that reframing it from rights to risks opened up new possibilities. Neither party left with everything they wanted, but they actually both felt that they gained more than they were expecting. So I thought that was a very positive resolution. And then finally, the structured buyout that we were able to organize meant that a solution, a business solution, was able to be found to the legal issues, but there had to be the right context set for the emotional win of the relationship being repaired, or setting a foundation for the repair of that emotional relationship that also had to be built in. All right, let's move on to the next slide, please. And we're going to talk about a duck pond up in Butte County. So, this is a case of Butte Creek Island Ranch versus Krim. It's a 1982 case. It's out of the 3rd District, and the parties were co-owners of a remote Butte County duck hunting ranch, I should say. Okay. It was a secluded ranch in Butte County's famous Butte Sink. It's a vital seasonal habitat for migrating ducks. And the ranch was composed of 2 parcels. There was parcel A 40-acre parcel with a sleeping house, communal dining building, garage, barn, really all the development. There's a small landing strip on that 40-acre parcel, but I mean, everything was pretty spread out. Meanwhile, parcel B was a 181-acre marshland ringed by the Butte Creek and the Sanborn Slough. The parcel A that had the support camp on it really supported parcel B, which is where the duck hunting occurred, is much more rustic but functional. So Krim was a man with generational ties to the land. He had visited the ranch annually since 1948. He inherited his half in 1971 and continued using the property heavily. Meanwhile, the Butte Creek Island Ranch Partnership bought the other half in 1978. When Krim refused the attempts to buy him out, they filed for partition. And the case ended up centering on whether the property should be physically divided or simply sold outright. Well, a court-appointed referee came up with a solution, proposed a partition in kind where each cotent will receive comparable hunting acreage on parcel B and half of parcel A with access via existing paths. And the approach seemed to preserve the value for both, avoided capital gains tax consequences, and considered how rare comparable ranches were at the time. It was practical, it was equitable, a solution designed to keep both parties whole without the disruption of a forced sale. But then one partner in the partnership side, remember it's Krim and then the partnership, of that partnership, one partner uh, decided he wanted the entire ranch. He planned to bid on parcel B himself, and he wanted to force a sale. So the court-appointed referees approach did not carry the day. Suddenly, the partnership was not willing to engage in this proposed settlement and demanded a sale of the whole property instead. And the trial court ended up granting that, agreeing to divide parcel A in kind and sell parcel B. All right. So Krim appealed because that was going to mean that he was cut out of parcel B entirely when that one partner ended up buying it at the sale. The appellate court here, the third district, reversed the trial court, and it did reaffirm California's statutory presumption of favoring a partition in kind unless the division would substantially reduce value or violate local subdivision or zoning laws. The forced sale, the court emphasized, must be strictly justified. And in this case, parcel B, a fertile migratory habitat, was without any comparable replacement property available on the market. Sale would most certainly diminish the value for Krim, both of what he retained in parcel A and the value he was going to get from parcel B, because who's going to go and try and buy parcel B that doesn't have any value or any interest in parcel A, right? So you have a limited market. And so Krim's going to end up getting the shaft on the pricing for parcel B as well as the enjoyment of parcel A. So when co-tenants are stuck, not because the law is unclear, but because their needs diverge, the question is to ask what's going to align with the statutory default and the emotional reality in this situation. And I think Butte Creek reminds us of that balance. Let's go ahead and go to the next slide, please, and talk about the key legal lessons. So partition in kind is preferred. Again, the appellate court affirmed the referee's recommendation. Statutory presumption favoring a partition in kind did carry the day, but here the division would substantially reduce the value. There was not an issue of that second prong test for the exception, which is if it would violate local subdivision or zoning laws. Also, a forced sale must be strictly justified. Due to the finality of the result of a forced sale, the court is going to look carefully. Here, they looked carefully. They saw that losing parcel B would be damaging to parcel A's owners, which would mean both Krim and the ranch. If left to only parcel A due to any other buyer making a successful bid on parcel B, and of course the damages there. Let's jump to the next one, if we could, please, here, and let's talk about the strategic mediation lessons to be had here. All right. So a law that favors in-kind division, unless impractical. It's about the complexity of applying the statute anchored in real-world stakes. Okay, we're dealing with a combined 221-acre duck club. To one party, the land was a legacy. To the other, it was a business. There were business impacts even to Krim, for whom the land was a legacy, that helped in the court's analysis of justifying why not to simply put parcel B up for auction. Further, the emotions in this case aren't going to erase statutory rights, but sometimes they justify those rights. All right, as here, the referee and the statute aligned with equitable division. The division plan thoughtfully addressed tax impacts, replacement scarcity, and use, an approach much closer to mediation, problem solving, right, than the statute that provided a very narrow resolution. Krim had long years of memories. He had been there every year since 1948 at the time. He had continued use while the Butte Creek Ranch, which was a partnership, it was a business, it had ambitions. Both perspectives and the parties' leverage on both sides mattered here, but the fact that Krim had a good story to tell about that use of parcel A as to why foreclosing access to parcel B would render parcel A of less value uh, showed why it could not simply be replaced. His value in parcel A could not simply be replaced with a sale forced by the court of parcel B. And so the here the mediators are going to have to balance the statutory defaults with the client realities. And the legal principles are part of the storyline that can be told. But I think that it's something where, again, it's a situation of looking at what is the total of the balance for the parties in the case. With that, I am going to ask him, yep, for questions. If we have questions here, please enter them in the Q&A. And okay. All right. We do have one question. Does the new Partition Act impact your views of partition? Um, it does some. I'm gonna be honest. This it hasn't been, in my opinion, tested sufficiently for us to see what the stories are going to be of what comes up. When I look at it from a mediation perspective, it's not necessarily just at the legal rights that are involved, but also, quite frankly, on how it triggers the emotional rights. When you look at these two stories of partition, they both were involving emotional matters. If these were situations where they were two businesses or business-minded folks, such as let's start with the Adam and James situation. If that were something where it was simply a matter of getting the best value, that would be an easier thing to figure out. It probably wouldn't have even required lawsuit being a lawsuit being filed, but unfortunately it did, and I think more of that was about the emotions involved than necessarily about the legal rights. The legal rights obviously gave rise to, well, let's just go with the lawsuit option. Um, that was a case where honestly they could have worked it out at a mediation before the lawsuit was filed by virtue of the clarity of the rights. I think the clarity of partition rights in the new Partition Act is going to create leverage, similar leverage for future situations, but it wouldn't necessarily solve the problem either with Adam and James or the fact pattern here from Krim and the co-owners of the Butte Creek Ranch. Hopefully that's helpful as an answer there. I'm open to answering any other questions. We have a few minutes remaining. If anybody has any questions, please feel free to type them in. And if not,
It looks like
then
we,
I am happy to thank everyone for your time. If we could go to the next slide, my contact information is there. Please feel free to reach out, whether you're attending this live or watching this later. If you have any either questions about what we've talked about today or questions otherwise where I can be of help, would love to speak with you. And then finally, if we could go to the last slide, please. These are the citations. As I said, these are provided in the written material. But these are the cases and statute that we discussed here today. So seeing that there are no other
It
questions posed
it
yet.
looks like we actually have some questions through that we received through email.
Oh,
I'll go ahead
great.
and read them off.
Thank you.
So, what tools or resources beyond standard title reports would you say are most effective in uncovering hidden risks or claims?
Hmm. So, well, it depends upon the particular risk that's involved here. In the case that we talked about for the city of Manhattan Beach, that's one where it would be beyond reviewing the title report and digging into the underlying documents, the deeds, any easements that may be involved, and also a visual inspection of the property and of the neighboring properties would be good for seeing if there are documents that should be there that are not, right? For example, there could be various utility easements that are apparent when you're on property, but are not contained or not documented in the title report. Then you have to try to figure out, is it that there are no written easements and it's a prescriptive right that you're dealing with? In that case, what are the limits of the prescriptive right, and what is that going to do for the your client's plans with the property? Um, the another useful tool, as I mentioned, would be retaining a historian to get an understanding of the use of the property. Now, it may not require a full-blown historian, depending on the community and where you're at. It might be something that a local historical society could be helpful in. This depends on the posture of where you're at. If it's something where the historical society has taken a position against the particular development, obviously that's going to be somewhat problematic to be able to get their help for a more affordable rate than necessarily hiring a full-blown historian. But if not, or not yet, it's something where it could be helpful. They can be doing the footwork for you. They have the area knowledge and understanding. And also, it could be something where you get those folks on your side for the potential future discussion if it's going to require some type of action by the city or other political jurisdiction where the local historical society may have sway. So that those would be where I would look to. And then beyond that, if there's a particular property or question or issue, I'm happy to, go ahead and reach out. I'd be happy to see if I have other ideas. Did
All
we have
right.
other questions?
Yes, actually. So it looks like we have two more.
Great.
What what strategies would you say are most effective for framing partition disputes in mediation so that clients can reach structured buyouts instead of prolonged court battles?
Uh, I think the key thing to bring to those mediations first and foremost is an understanding of the valuation and backup. There's uh, a lot of times folks will come into those discussions with an idea of what the property should be worth. They'll come in with comps from the neighborhood that are not necessarily on point. To the extent that you can have, I mean, even independent data sources, not that Zillow or anything like that is going to be the end all be all, don't get me wrong, but those can be helpful data points. Honestly, what I find works best will be an area realtor who knows the market, who can succinctly explain why certain comps are of value and while certain comps are not of value. To be able to have that person available as an expert on call is ideal. But if not, and not only is it ideal, but also quite frankly, it's usually more cost effective because otherwise you're talking about getting a realtor to prepare a written report. I don't know that you need an appraiser per se. A situation may call for an appraiser as part of the settlement, right? But I don't know that you need to bring that to the mediation. What you do need to bring is as much as you can about the valuation and the why of the valuation, because what is it that the other side is trying to do that you want to avoid, and telling that story in mediation as to why it's going to be a diminution of value, and how to be able to address that. I see a question in the Q&A, but was there another question that came in by email that we can address first?
Uh, sure. Let's see. It is, would you say there are some reoccurring blind spots you see litigators overlook that create unnecessary exposure for their clients in these cases?
Yeah, I would say that from what I've seen, the partition actions are most interesting, I think, in terms of the emotions, but in terms of practicality, it's not taking into consideration the impacts of land use regulation and what that really means, right? A lot of folks who may not be familiar with the jurisdiction come in and they look at what the code says, they look at what the general plan or specific plan documents say, and they think that they've got a roadmap. And that's just not the case because, again, it depends on the project and the size of it. But if it has political implications in the jurisdiction, excuse me, it's going to be something where you have to plan for that beyond just what's in the documents, right? Um, and then the other main area of issues I see is around title and what exactly grants are, grants of easements, prescriptive rights, things of that nature. Those tend to crop up a lot, at least in my practice. Okay, let me take a look here. I'm going to read the question off. I understand that real estate brokers representing a client don't bother reviewing title reports. No comment. But if a lawyer is involved in representing a buyer, I've always thought that reviewing the actual documents referenced in the report is part of the buyer's lawyer's job, unless somehow excused from it by a property limited scope of representation. The city of Manhattan Beach had to know up front that there was an issue before they closed on the sale. Am I wrong? So I don't know that there's specific. I mean, I agree with you in practice. I think that that's absolutely the correct approach to be taking. I don't know, and I don't know at the time in the 1980s that there's a specific ethical obligation for the buyer's lawyer here, the city of Manhattan Beach's lawyer, to have reviewed all of the title documents. That being said, putting that aside, it's obviously best practice. I think that what may have happened here is it may have even been reviewed and just not considered. Because remember, the case did turn at the end on the quitclaim language that was in that document. Okay. So if you're the lawyer, if somebody's going back and saying to them, well, we had to go through all this litigation because you didn't review it, that lawyer could say, well, I reviewed it and I saw the quitclaim language and I thought that would carry the day, which it did. Okay, technically correct, right? Um, I wonder more. What I find more intriguing is on the plaintiff's side in that case, the heirs to the Redondo Beach Land Company, and how exactly that came together, how they found out about this, how they ran this lawsuit, what their expectations were, who invested in this, in essence. That's the part I would love to learn more about, quite frankly. Uh, but no, I think that you're right. So, okay, we're at time. So, thank you for the questions. Appreciate those and appreciate everyone's attendance and time today. Have a wonderful rest of your afternoon if you're listening live, and if not, a wonderful rest of your day. Take care.